Black immigrants, who have been victims of police brutality, right? You have Amadou Diallo in New York. There's different names, right? And so, again, I'm just doing my due diligence in terms of, highlighting all the different ideas that are coming around in the reparations space. But also, I agree with member Joan Sawyer and Senator Bradford in that, we have a unique opportunity to, listen to and adhere to the intent of Secretary Weber, who authored the bill. Member Tamaki, you are recognized.
Oh, thank you. I mean, I have to say, as the only non-Black member of the task force, I kind of like, far be it for me to determine eligibility. I'm looking at all your faces, and you've spent a lifetime wrestling with this issue and all its ramifications. And not only, as to yourselves, but, your families and your ancestors. It's deeply, deeply personal. So I tread lightly, understanding that. Without indicating, where I stand, because I do feel similar to Dr. Grills, I'd like to hear more. It almost sounds, as explained by Assemblyman Joan Sawyer, that the two avenues are not necessarily mutually exclusive. And that is to say that you start with a harms-based review, and you make a comparison of 400 years of slavery versus 100 years of Jim Crow versus X number of years of redlining and so on, and you try to right size the remedy to the harm. And I would be curious to know if any of the task force members disagrees that it is binary and either one or the other, or rather seeing racism as a continuum, which begins with transatlantic slave trade and morphs into all of its, horrific permutations that can be individually recognized and remedied. I do sympathize or empathize with what Dr. Grill says for those who can't trace their ancestry back for a variety of reasons. I mean, where do we stand on that? I read From Here to Equality and brilliant book. But at the end, I sort of wrestled with those, concepts of how do you do this? The other piece of it, I would say, and again, this is neither here nor there, this is just for consumption. Whatever the task force decides is going to resonate not only in California, but nationally. The press is going to pay attention to this. The report is going to have the imprimatur of the state of California. And like so many things that begin in California, it influences the rest of the country. So it's very, very important that we bring the public along with this. And I'm totally in agreement with Lisa Holder that this has got to be communicated out. And my understanding is we're in the process of finding a communications consultant to help to do this. I totally agree about getting more witnesses, expert witnesses on this. I think that's would be a great help to the public. And then we have 12 listening sessions that have been organized or in the process of being organized by Dr. Grills, with UCLA being the convener, and perhaps some of the other institutions involved like Berkeley and others involved. I mean, that's a great opportunity to hear from the public, both individuals, organizations, and cities and local governments, on this issue, to help us basically figure out, how you identify the harms and then remedy them. But I guess my threshold question here is, it sounds like both views can be accommodated, or is that a naive observation on my point? That you can both recognize the terrible harm of 250 years of slavery, but you could also recognize Black Africans who immigrated here in, during Jim Crow or during redlining or in however else. And final point. Whatever the lens we use, I'm just wrestling and trying to figure out how that lens is applied to the other things that we've heard, whether it's segregation or whether it's terrible health outcomes because of discrimination and disparate levels of care, whether it involves political disenfranchisement that we've read about in the outlines, how that is impacted. And in other words, if we focus on one degree of harm and say Americans descendants of slavery, how then does that lens impact the other harms that we're talking about and how you remedy those? So I don't have any answers. I'm very anxious to hear, what other members say. So I'll stop here. Thank you. If that makes sense.
This is Member Holder again. Just wanted to jump in. I got cut off for a few minutes because of some technical difficulties, so I hope I'm not reiterating what someone has already said. I think it's important that our discussion is informed by, the scholarship, the thought leaders on these issues, and I think one realm that we should be looking to is the legal realm, and looking at things like mass tort cases, where, you have to create a framework for repairing massive communities who have been impacted by some sort of harm, but you have to do it in a way that's stratified because some people experienced greater harm than others, right? So if you're dealing with like a blast, like something blew up, if you live closer to the blast, obviously you lose your house, you might lose a family member. Your harm is much greater than someone who lives miles and miles away from the blast. And so that's how litigators deal with mass tort situations, and that's how they develop a framework for compensating people for the level of harm that they experience. So I do think it would be helpful to look at those types of frameworks, have witnesses who deal with those types of situations come in and talk to us about developing a stratified framework like that, just as something to explore. There are attorneys who, for instance, deal with issues of racial justice, and they look at the harms of racism as a mass tort, or as a nuisance type harm, and they come up with these types of schematics for figuring out how to allocate harm and how to allocate damages. So I think it would be worth having people who work in the field, practitioners, come in and give their opinion on that to this task force.
Yes, Member Monica Montgomery Stepp, you're recognized.
Thank you. I just want to quickly chime in because I am too just taking it all in, but of course using the premise of what we're doing as as AB 3121. And I think the intent is strong with regard to special consideration for African Americans who are descendants of persons who have been enslaved, and also just appreciate members Joan Sawyer and Bradford for that kind of more of a behind the scenes play by play as to what went on with regard to this bill being passed and what the what you both were signing on to, or what you felt you were signing on to. I do know Dr. Weber, and I know, from her, professor days, and this has always been a focus for her. And so I can kind of glean that from that personal experience with her. But I do think it's definitely worth the conversation, and probably worth putting in the proposal kind of these different periods of time and what the impact of slavery and the use of the Black body as a commodity, and just how that has impacted folks who, all of us, and then Black people who came here from their countries. So I just want to add that to the conversation, because this is a sort of a straw poll. That is where I stand. Would love to hear more from Dr. Weber and from other experts about how we put together a proposal that is sound around these issues. I don't like the either or. I want to explore the and behind this, but with the premise, of course, of descendants of slaves. So I think that's all I have for now, but just wanted to add that.
Thank you, Member Montgomery Steppe. I would just like to take a brief moment to complete a thought that I had. And so, I referenced Black immigrants who have been victims of police brutality, which is something that we should definitely acknowledge. But at the same time, this is conversations that I've had, throughout the reparations space. Like, as we have to be careful not to conflate the entirety of the Black American experience with police brutality, right? Like, our 400-year history, on this side of the world is so much more expansive than instances of police brutality, which should absolutely be addressed, right? But I kind of want to just get away from the notion that, that experience defines the Black American experience. There's so much other things and variables that define the Black American experience specifically. And I think someone brought up in public comment earlier today, actually, the Color of Wealth report, which was actually written by William Darity and some other scholars from UCLA. And so they, did a disaggregated a data collection gathering of sorts around wealth, right? What does the color of wealth look like in some of these major cities like Los Angeles and Boston and Miami? And in the city that I'm from, Los Angeles, they found that U.S. Blacks, or Black Americans who descend from chattel slavery, have a median wealth of $3,500. Japanese families have a median wealth of $592,000. Asian Indian families have a median wealth of $460,000. African Blacks have a median wealth of $72,000. Koreans, $23,000. Vietnamese, $61,000. Filipinos, $243,000. And so you just let's juxtapose the wealth differential between U.S. Blacks in Los Angeles and African Blacks in Los Angeles, for example. U.S. Blacks, again, have a median wealth of $3,500 to $4,000 compared to African Blacks who have a median wealth of $72,000. And so, that's a stark differential. And I think that's part and parcel as to why there needs to be, or why the bill was written the way it's written, to make sure that we are accounting for that particular group, Black Americans who descend from chattel slavery in the United States. We have about 10 more minutes left in this discussion. Again, this is just, a free-flowing conversation where we're taking a straw poll of sorts, seeing task force members, perspective and worldview on this particular issue, with the notion and understanding that our perspectives and attitudes may evolve over time as we bring in more experts and people to provide personal testimony. And as Member Tamaki said, we have a series of listening sessions coming up soon And so those sessions would be absolutely essential for getting more community input on this very critical topic. So at this time, would any other members of the task force like to provide any last questions or comments on this topic?
Before we lose the opportunity, as we've all expressed, this is an iterative process. It's ongoing. It's going to evolve. Is there some sort of action item that we need to put in place to make sure that we can continue to have this conversation, to continue to have witnesses inform and help us outline this conversation to ensure that we can get Dr. Weber and some other folks that might be very insightful into the conversation? Is there some action item that needs to happen?
That's a great question, Member Holder. So tomorrow, oh wait, I see the gray symbol. Is this the staff member that wants to speak, or is someone inadvertently muted? If not, I'll just proceed to answer the question. So tomorrow at 3 to 4, we are going to discuss agenda items for the December hearing, discuss some of the key items that we would like to discuss in December. So in the event that we want to continue this conversation in December, we can reserve any potential action items related to community of eligibility tomorrow at that reserved time. If we want to have this conversation at a future hearing, we can make a motion about that too today. But I just wanted to highlight that tomorrow at 3 to 4 p.m., that's where we're going to be talking about some of the key or major items that should be included in the December hearing. But also I wanted to flag, if people wanted to create a motion or form a motion as a preliminary motion as to who we regard to be a part of the community of eligibility, we can, but personally that might be a little premature. But that is something that we can do now, just to put on the record. It's just an idea, not something that we have to do at all. The whole point was just to start the conversation. And we can put it on the agenda in the future. Like I said, tomorrow at 3 to 4, or any public hearing, we can make a motion. We want to have this on the agenda moving forward.
Madam Chair, shouldn't we not have an official position on inviting our Secretary of State? Is that the common consensus?
Sounds like it could be. So at this time, would anyone, any task force member like to entertain a motion regarding the experts that we should bring into this conversation?
Madam Chair. Madam Chair.
I don't know who's speaking. Is that Parliamentary Johnson?
It is, yes. I just wanted to tell you that Dr. Scott Lewis had his hand up before, so he may want to contribute to it before a motion is made.
Thank you for that. Member Scott Lewis, you are recognized.
Sorry, that was from before, I think, or maybe it was an accidental gesture.
Okay, thank you for that. Okay. So would anyone like to entertain a motion regarding this agenda item?
Madam Chair, I move that we would agendize a time appropriate for our Secretary of State, Weber, to come and address the body.
Second.
It has been properly moved and seconded that we invite Dr. or Secretary Weber, the task force, when appropriate, to come back and discuss her intent regarding the community of eligibility. Is there any discussion on this matter? Hearing no further discussion, I will now turn to Parliamentarian Johnson, who will turn to Ms. Belton so that a roll call vote may be established. Parliamentarian Johnson?
Yes, thank you. Ms. Belton, would you please call the roll for the vote?
Thank you, Chair Moore and Parliamentarian Johnson. We will now vote in order by task force member. Chair Moore, your vote, please.
Aye.
Chair Moore votes aye. Vice Chair Dr. Brown?
Aye.
Vice Chair Dr. Brown votes aye. Senator Stephen Bradford?
Aye.
Senator Stephen Bradford votes aye. Dr. Cheryl Grills?
Aye.
Dr. Cheryl Grills votes aye. Lisa Holder?
Aye.
Lisa Holder votes aye. Assemblymember Reginald Jones Sawyer?
Aye.
Assemblymember Reginald Jones Sawyer votes aye. Dr. Javon Scott Lewis?
Aye.
Dr. Javon Scott Lewis votes aye. Don Tamaki?
Aye.
Don Tamaki votes aye. Councilmember Monica Montgomery Stepp?
Aye.
Councilmember Monica Montgomery Stepp votes aye. Madam Chair, on the motion, there are 9 members present and voting and 9 aye votes.
Thank you, Ms. Belton. The vote was 9 ayes and 0 nays. The ayes have it, and the motion carries. Thank you all to the task force members for engaging in this discussion around community of eligibility. And I'm sure I can speak on behalf of the public to say we're looking forward to continuing these conversations and developing what the community of eligibility will look like. Now, I would like to turn to agenda item number 8, which is the break. So, yes, the break. So we're about 5 minutes early, which is great. So we'll convene back at 3:45. So we have a 20-minute break as opposed to a 15-minute break. And then we will come back at 3:45 for a presentation from Michael Newman regarding the subpoena power of the task force, and then Department of Justice updates, and then the meeting will conclude for the day. We'll be in recess for the day. So come back at 3:45. Thank you. 8:45. We will now turn to agenda item number 9, potential action item, subpoena power of the task force. But before we do so, I'd like to turn it to Parliamentarian Johnson, who will then cue Ms. Belton so that a quorum can be reestablished. Thank you.
Thank you, Madam Chair. Ms. Belton, can you please call the roll to establish a quorum?
Thank you, Chair Moore and Parliamentarian Johnson. We will go in order by the members of the task force and ask that each member indicate their presence. Chair Moore.
Present.
Vice Chair Dr. Brown.
Present.
Senator Stephen Bradford. Dr. Cheryl Groves.
Present.
Lisa Holder.
Present.
Councilmember Reginald Jones Sawyer. Dr. Javon Scott Lewis.
Present.
John Tamaki.
Present.
Councilmember Monica Montgomery Stepp.
Present.
Chair Moore, there are 9 members of the task force and 5 members are needed for quorum. There are currently 7 members of the task force present. A quorum has been reestablished.
Thank you very much, Ms. Belton. Now we will turn to agenda item number 9, potential action item, subpoena power of the task force. This agenda item will run between 3:45 p.m. and 4:15 p.m. I would now like to recognize Michael Newman and remind members of the task force that we received a copy of the upcoming presentation in our meeting materials. Michael Newman, you have the floor and may begin when you're ready. Thank you.
Thank you very much, Chair Moore, Vice Chair Dr. Brown, and the members. I think that the presentation is supposed to be shared. Trini, or there we go. So thank you very much for allowing me to present on this very important point. My name is Michael Newman. I'm the head of the Civil Rights Enforcement Section, which provides support to the task force in carrying out, especially its legal, in addressing its legal needs. This presentation is going to be in regard to the task force's power to issue and enforce subpoenas. Can I have the next slide, please? So the task force has the authority to obtain information in a number of different ways, as delineated in Government Code Section 8301.3, which is the task force's statute, which is AB 3121. There are a number of different types of information the task force can obtain. It's empowered to request the attendance and testimony of witnesses, to request the production of books, records, correspondence, memoranda, papers, and documents. And it's also empowered to acquire directly from the head of any state agency available information useful to the task force's purpose. Can I have the next slide, please? The task force has an implied power to subpoena. This is because although Government Code Section 8301.3 does not include an explicit authorization to obtain information via subpoena, it does implicitly authorize subpoenas because it sets forth the task force's ability to seek an order from a superior court compelling testimony or compliance with a subpoena. Therefore, though not explicit in the statute, the clear language authorizing the task force to compel compliance through a subpoena strongly implies the power to issue subpoenas in the first place. So what can the task force subpoena? The task force can subpoena witness attendance and testimony, though the location must be reasonable to avoid witnesses having to travel too far. It can obtain documents as specified, books, records, correspondence, memoranda, papers, and other documents. But it's important to note that this likely only applies to entities in California who conduct activity in California or whose activity affects California residents. So what does it mean to issue a subpoena? A subpoena is a legal document which must be served on the recipient. The subpoena must provide a reasonable period for the person subpoenaed to respond, which is called due notice. And the demand for information contained in the subpoena must be sufficiently definite for the person subpoenaed to understand exactly what is expected of them in response. So therefore, the subpoena should clearly state what the task force is requesting, and the subpoena should have a defined time period for the information sought in the subpoena. What does it mean then to compel compliance, which is this next step explicitly stated in the statute? If an entity or person who is issued a subpoena refuses to provide the information sought by the subpoena, attorneys for the task force would have to file a petition to initiate a legal proceeding to enforce compliance. When the court makes a decision in the case, the court will ultimately determine what, if anything, the entity or person must provide to the task force in response to the subpoena. This process could take several months, and it could take longer if there is an appeal. There are legal limits on subpoena power. The limits are ultimately determined by the court in an enforcement lawsuit if it comes to that. The court could determine that the information sought was not reasonably relevant or pertinent or material to the task force's mandate. A court could also determine that certain legal privileges allow the subpoenaed entity or person to decline to disclose certain information. For example, there's a privilege against self-incrimination, though that would not extend to corporations or corporate custodians of record. And there is the attorney-client privilege, the spousal privilege, or other evidentiary privileges that would apply. So in conclusion, that's a brief introduction to the power to subpoena, what subpoenas can include, what you can obtain through subpoenas, and now there are some decisions for the task force to make. The task force must decide whether or not subpoenas should in fact be utilized. There are choices for developing the subpoenas. Pursuant to Government Code Section A301.3 and AB 3121, the task force can delegate this authority to determine how a subpoena should be drafted, what it should be included, what it should seek, to one member who can work with our staff in the development and issuance of the subpoenas. Pursuant to that same subdivision, the task force can create a subpoena subcommittee for the purpose of decision-making on subpoenas. This subcommittee would also be subject to the Bagley-Keene Act's open meeting requirements, or the task force can handle the subpoenas as a whole body. If the task force chooses to handle subpoenas as a whole body, but still wishes to delegate to a smaller group in order to develop the subpoenas outside of the task force's meetings, so as not to utilize time in the meetings, the task force is able to vote to have two members serve on a subpoena advisory committee. These two members could work to put the subpoena together, including making decisions as to the scope and content of the subpoena, but the final proposed subpoena would need to come before the full task force in a regularly scheduled open meeting as an agendized item for final approval by the full task force for issuance on behalf of the task force. This would save the time of developing and crafting the subpoena in the meeting, but still, if the task force doesn't delegate to one member or to a subcommittee of up to 4 members, this is how this is a more efficient way that the task force could choose to handle this as a whole body. Finally, once those decisions are made, the decisions that remain are who or what entity should be subpoenaed and what information will you be seeking to obtain. That concludes my presentation, and I refer back to the chair for the discussion, or if there are any questions for me.
Thank you, Mr. Newman, for the presentation. Now, I would like to facilitate a discussion amongst the task force members regarding the materials on the subpoena power and the questions that Michael Newman posed towards the end of the conversation, not necessarily the questions about who or what entity we are looking to subpoena or what information that we would like to obtain from those entities or individuals, but more of the preliminary questions about, in the event that we do utilize this power, what will be the structure by which we do that? So again, thank you, Michael, Mr. Newman, for coming up with some creative ideas. So to summarize, there could be one individual task force member who is assigned to facilitate the work around subpoenas with the DOJ staff. There could be a subcommittee of 2 or more members, with the caveat that such subcommittee would still be have to be adhered to Bagley-Keene provisions, or would the task force like to cover subpoenas as a body, as a whole, as a 9-member body? And so, does any task force member have any strong opinion as to what's more preferable? If so, please feel free to share. Member Tamaki, you're recognized. You're on mute, Member Tamaki.
In determining the how the subpoena is to be shaped and what the contents of it would be, it seems that there would be a discussion containing confidential information as to the strategy of the task force and what is being sought and what possible defenses there might be to the subpoena. If it's a private entity, they would have the right to quash it if they successfully assert certain privileges. And so if the subcommittee is formed that's subject to the Bagley-Keene, then that becomes a public meeting, right? So there probably wouldn't be an attorney-client privilege there. And so I'm just struggling with how that would be done if it's done by a subcommittee or the task force as a whole. It seems to me that the way to do this is for the task force to identify the target, and then one person for the task force would work with the DOJ to fashion the subpoena. But maybe the other litigators on the task force, might have a comment. Lisa or Camila, you might have a different opinion, but just thinking out loud, that seems to be an issue.
Yeah, I agree, because there is this whole deliberative process that should be privileged. And maybe the DOJ, Michael, can weigh in on what is available to protect that deliberative process, whether we could have a closed session if we did form a subcommittee.
Sure. Chair Moore, would you like me just to respond?
Yes, sorry, I got corrected. Please mute if your mics are on. But yes, Mr. Newman, please respond. I was going to say I'm no longer a litigator. I moved on to transactional work, so I'm probably not the best person. Go ahead.
Oh, thank you. Thank you very much. So I'm sorry, Member Holder, you're asking about closed session. That's correct? So in our internal discussions with the experts in our office on some of these issues, including Bagley-Keene, the closed session, in order to go to closed session on a reasonable expectation of litigation, it is our preliminary understanding that that would need, again, a reasonable expectation that litigation is going to occur. So for example, in this situation, if we've issued a subpoena and somebody has indicated that they're not willing to comply with a subpoena and we need to consider our options, those attorneys on the task force may be familiar with the meet and confer process. So if we are in a meet and confer process, and somebody is refusing to produce documents, and a decision needs to be made. Are we satisfied with what we got, or do we want to file a petition to enforce compliance with the subpoena? That would be a litigation decision, and we would be able to use closed session in order to have those discussions. But as you know, I can look into it and return back to the task force with a further analysis if there are different factors at issue, especially depending on what the task force decides in terms of proceeding. But at this juncture, simply putting the subpoena together and making the decision to issue it would not satisfy the requirements of reasonable expectation of litigation, anticipation of litigation discussions.
So this is a question that I posed to staff some months ago, but could you, Mr. Newman, could you provide clarity on the types of subpoena that we can utilize? Because, for instance, like a subpoena ducis tecum, that is a particular subpoena that is for the request of documents, which then the an entity can move to quash that subpoena. But can you just, because there's different levels, I would think, in terms of the inherent power, like a subpoena ducis tecum versus another type of subpoena. Can you explain?
So yeah, as you mentioned, there are a number of different subpoenas. The citations, for example, in the PowerPoint presentation that I just gave are to Government Code Section 11180, which is the administrative authority of the Attorney General or any other head of an agency. Those, for example, have their own procedures and are not subject to quash, but they are subject to a petition to enforce, which is the language that I've been using. So it really does depend, it'll depend on how we analyze the documents or information that we want to get, and what type of entity it is and how we're collecting the information, and might differ depending on the different subject matters and targets. So that would be something that we would have to analyze, sort of in the process of compiling the subpoena. But again, if you'd like us to do an analysis of different potential types of subpoenas, just for the awareness of the members of the task force, or else we can, if the task force decides to take one of the other approaches, we can work directly with whoever is designated to work on this to work through the different preferred types of subpoenas that we would issue.
That was helpful. Does any other task force members have any comments or questions for Mr. Newman regarding this action item or this potential action item? And I want to say, tomorrow we meet again. And again, the last hour of the meeting, we will be talking about what will be on version and, just to get a feel to decide which approach we want to do out of the 3 suggestions, right? Do we want one task force member to be assigned to this? Do we want to form a subcommittee? Should we deal with this as a 9-member body? Please let me know if, we feel that we're in a space where we can decide upon one of those 3 approaches now, or if this is something that we want to discuss and in terms of an action item for tomorrow or even for the December hearing. Just putting that out there.
So I'm not well versed on subpoenas, but I'm wondering 2 things. One, and I know there's no typical, but if we had to force the issue, what's the typical time it would take to put together a subpoena, issue it, and then start negotiating with the entity that the subpoena is being sent to determine compliance and then get the information. Are we talking a few weeks? Are we talking months? Because I think that would help us to determine how judicious we need to be with invoking the use of subpoenas. So that's one question. The second question, or the second point, is related to which method do we want to use? I would think, aside from the obvious, that someone with a legal background would probably do better to work with DOJ on crafting a subpoena. However, depending upon the nature of the subpoena, the type of information that's being solicited, it might make sense for a certain task member to be involved rather than another because they have a particular understanding or knowledge of the subject matter and would know how to best shape what is being requested in that subpoena. So I'm not sure, and maybe we may need to be flexible about, how we approach that.
Mr. Newman, could you just provide a general overview based on maybe your previous experience, or just in general, was the timeline, the expected timeline potentially?
Sure, no problem. Generally speaking, and I'll start, this is all very general. Obviously, each individual subpoena could be completely different, depending on the cooperation of the subject of the subpoena. But starting from the time that, we issue the subpoena, obviously not factoring in however we get to the point of being authorized to issue the subpoena. Starting from the issuance of the subpoena, we would need to give the respondent a reasonable amount of time to respond. That can be 30 days, that can be 45 days. Part of that can also be, as I referenced earlier, a meet and confer process, where if we're asking for voluminous records, the person who, or the company or the entity that we've sent the subpoena to will say, I can get you certain things in 30 days, I can get you some more things 15 more days later, I can get you some more things another 15 days. And so we would work out a timeline. Generally speaking, again, if they're cooperating and we're talking about a lot of documents, that production could take place over the course of months. Where probably 30 days would be the shortest amount of time. And, if they're cooperating and producing documents, it could be a long time. They could keep producing batches for a while. And then, theoretically, if they don't want to respond and we're at 30 days pass and 60 days and they're still not willing to, and we come to the point where we want to initiate a litigation, we'd have to file the petition. We could ask the court to expedite the process, which is for non-attorneys, that's an ex parte application. We'd have to justify why. Obviously, the task force has a limited amount of time in which to conduct its business. So we could ask the court. The court can say no. The court could say yes or no. And then we would have to sort of make our case to the court. That hearing could be scheduled, it could take place pretty immediately, or it could be delayed on the court's calendar, depending on the court, how busy the courts are. They tend to be pretty busy right now. So I would maybe estimate, that's going to be at least probably 6 weeks. If we win on our petition, as I mentioned in my PowerPoint presentation, the respondent to the subpoena could then appeal, and those appeals can take a long time. In reality, if it goes up on appeal and it gets appealed, unless we get sort of an extraordinarily expedited appellate process, it would take many, many months, probably in the realm of a year. So I hope that answers the question on timing. If you have any other specifics, please do. On the question of methodology or anything like that, we obviously in the DOJ defer to the task force's decisions on those.
That
Yes, Chair Brown,
definitely. Oh, I'm sorry. I was just going to say that definitely answered my question. It's what I suspected, which means that if we are going to do any subpoenas, we probably want to do sooner than later in our process.
Yes, I agree, Member Grills. Member Brown, were you trying to speak or no? Probably no. You're okay now. Okay, so we have 5 minutes left for this agenda item. Again, this was listed as a potential action item, so we don't necessarily have to take action on this item at this very moment. Again, we have space and opportunity to come back tomorrow and discuss this towards the later half of our hearing. We can also, agendize this for December as well, or we can take a formal vote as to which approach we want to take, after some deliberation and thought between now and November, or we can, decide to do this now, or even tomorrow. I'm just putting out there some different ideas. But at this time, would any task force member like to entertain a motion regarding this potential action item? Also want to give space for that. Okay.
I think it's probably helpful to give people a day or so to think about how they want to operationalize. Maybe we can revisit it tomorrow.
Yeah, I agree. It's a lot to think about and to strategize through. So I think that would be best where, as an assignment for all of us, we can think through this later on this evening and come back tomorrow and figure out our next steps. Does that sound good for everyone? Is there any opposition to that proposal? Okay, great.
Can I ask a
Okay,
question
well,
more?
yes,
So one
Member.
I have is the more practical. Is there a particular industry or company or specific thing that, for example, is needed in order to assist in the calculation of damages that the task force would be very interested in issuing a subpoena on? Do without disclosing anything too deeply that I would probably prefer would be discussed with the DOJ outside of a public meeting, but is there a specific issue or interest in mind?
When we've had the scholars speak, I've raised this issue, like what industries would be on their wish list for a subpoena, and I know that some of the responses, perhaps had to do with banking, predatory lending, realty, the realty industry, and some of the predatory housing processes we've talked about. So those are certainly at the top of the list, the banking and the real estate industry. But again, this is a strategic process, so I think we only want to disclose so much on the front end.
Right. I had the same thoughts as Member Holder. For example, this morning, one of my questions would have been what would have been on the wish list around housing and education, because, well, for many reasons. There are pieces of information that could help document the damage in both education and housing, including like specific realty companies as well as governmental entities.
Vice Chair Brown? You're on mute. You're
These redevelopment agencies, records maybe, should be subpoenaed as to how they have dealt with these nonprofit developments that were established by faith communities 50 years ago. And secondly, how that lottery system has worked adversely against the interests of the Black community and caused the decrease of population in many of our urban communities.
I would also think we would want to look at insurers. Theoretically, most of the documents from the time of slavery should be public record, but I don't think that's the case. So, insurance agencies that still exist today existed 300-400 years ago and were insuring the ownership of human beings as property. So we may want to think about focusing on insurance agencies to get some of that antiquated documentation to see,
Thank you. And I just have one quick clarifying question for Mr. Newman. So in the presentation, it was stated generally that, the powers most likely will be prescribed to, entities and policies that have an impact on California residents. So like there's an implication that, if there's entities outside of California, it may be hard to reach them in terms of our subpoena power unless we can find a finding that their policies have impacted California residents in some way. But my question is, well, I guess it comes down to lawyering, but my question is, can federal governments also be a part of the scope in terms of federal government entities? Could that be part of the scope of our subpoena power if we can kind of make that argument, right? That federal government policies have impacted California residents in some way?
So there's a few different questions in there, which sorry. Does the chair recognize me to answer the question?
Yes, you're right.
Sorry. I just jumped right in. So there's a couple of questions in there, which I'll try to answer quickly with the limited time. So first is the task force, the AB 3121 made clear with regard to being able to get documents from the state. Our ability to effectuate a subpoena or assert any kind of control over the federal government is limited, and we'd have to do an analysis as to whether there are whether there are different entities at the federal government that may be governmental entities or quasi-governmental entities. More likely, there would be avenues such as the Freedom of Information Act or requests or other things that we could consult with you on as your attorneys in terms of ways of getting documents through that way. To your question about entities outside of California, we would have to do an analysis of it's sort of case by case. We'd have to look at the entity we'd be subpoenaing and what their contacts are, and ultimately the decision, as I mentioned, would be with the courts. If we end up trying to enforce it, that it would be, and they resist, then it would be a decision from a judge that would make the ultimate determination.
Thank you. Are there any last comments or questions from task force members, Mr. Newman, regarding this topic? Okay, if not, we will table this discussion for tomorrow. I'll make sure that we bring this discussion up tomorrow so that we can get to the action item. So again, in terms of what we should do between now and tomorrow, continue to ponder as to which approach you think the task force should take regarding our subpoena power. Do we want to assign one particular task force member work with the DOJ to formulate these subpoenas? Do we want to form a subcommittee of sorts, which will be, we have to respect Bagley-Keene provisions in order to do that? Or do we all want to address the subpoena power topics as a 9-member body? So that's something that we have to ponder upon this evening so that we can have a more informed and robust discussion tomorrow.
Madam
So
Chair.
now, yes,
Madam Chair.
you are
Yes.
recognized.
Thank you. You are seeking to move this to an item on the agenda for tomorrow. I just checked the agenda and it's not listed as an item that you can discuss tomorrow. You can today set either a subcommittee and have that discussion and place it on December's agenda where your committee can report out. But there's nothing on tomorrow's agenda that allows for this to be moved to that date as an action item.
Okay, Parliamentarian Johnson, I was under the understanding that this could be discussed in agenda item 18, which is the agenda for the December.
You can discuss
right?
it, right? You can discuss it tomorrow as an agenda item for the 18th, but you can't vote on it tomorrow as, as an action of what you're going to do, because you have to follow the Bagley-Keene Act and, make sure that it's noticed for the appropriate time. But you can act on it tomorrow to determine if you're setting it for an agenda item for the December meeting. See what I mean?
Yes. So I'm clear on the second suggestion. So if we decide to, in the last hour of tomorrow, put this on the agenda for December so that we can discuss this on the agenda, but I do want clarity as to, are you offering a suggestion for
Yes.
if we do not want to delay this for December? Can you repeat what the suggestion is?
Okay, my suggestion is that today it's on the agenda for an action as to whether or not you're going to move forward. This is the same thing that you were earlier discussing as to whether or not you're going to have a subcommittee where you can discuss with the Attorney General what you want to do in terms of setting forth a particular subpoena, whether or not you want a distance taken, whether or not you want an action for a person to come in to do a personal subpoena, whatever action you want to take, so that between now and December, your subcommittee can meet and you can have that full discussion, report back to the December meeting, place it on the December meeting, and then state what your subcommittee has come up with. They can have a full discussion of that at that time and vote on what action you want to take in terms of the subpoena. But in the meantime, between now and then, you can today vote on having a subcommittee or one person, however you want to do, whatever you want to do in order to get the action for the full body at the December meeting. Does that work for you?
Okay. Yes, so your suggestion is that we take action on this item now, because
Yes.
that's what allows.
Yes.
Okay, that's what you're
right.
saying. Okay.
right. I know.
No problem. Thank you, Parliamentarian Johnson, for that clarification.
You're welcome.
Okay, so
Ms. Holder is seeking your attention.
Member Holder, you're recognized.
I'm just going to put this out there as a suggestion, and I certainly don't want to volunteer anyone, but I think I'm a litigator very actively. Don is a litigator pretty actively. I'm happy to work with Don on these issues. People are comfortable with that. If Don is comfortable with that. But I would just put that out there as a possibility.
That's fine. I mean, the two of us, my understanding is not a subcommittee, and then our communications would not be subject to public disclosure, which would be a problem, I think, in crafting subpoenas or even talking about potential targets. So that's fine. I'm not actively litigating to the extent I used to, but be happy to talk to and work and support Lisa Lisa's leadership on this, and happy to assist.
Okay, thank you, Member Tamaki. So I have a question for Member Holder. Do you all, well, what is your opinion about adding another member responding to Tamaki's concerns about the trade-offs between a two-member versus maybe another? Does that make sense?
I have very similar concerns. I do think that this is a very strategic process when you're talking about when you're talking about issuing subpoenas, and I would feel more comfortable doing this in a closed session if that were a viable option. It doesn't sound like it is. So I think a two-person committee that doesn't implicate Bagley-Keene may be a way to move forward.
Okay, thank you for that.
Madam Chair, I'd like to offer motion that a two-member committee would handle the matter.
Yes, Mr. Newman, were you trying to say something?
Yes, Chair Moore, sorry, that was a sort of a reaction response, inadvertent reaction. But if I may be recognized, just to clarify and take this back to the presentation I provided before, may I speak for just a moment?
Yes, you're recognized.
Thank you. So if you look at it, the slide doesn't have to be put back on, but if you'll reference the final slide, I referenced the task force can handle subpoenas as a whole body, and then I mentioned in my remarks that can be accomplished by, I think, what Parliamentarian Johnson mentioned and what Member Holder and Member Tamaki are talking about, which is an advisory committee that works on the subpoena and would work on the subpoena. And then to Parliamentarian Johnson's point can be agendized tomorrow for return back to the full task force for determination by the full task force for action through an action item. So that is right in line with what I mentioned in my presentation and in response to an earlier question I believe I had from one of the members.
Okay, thank you, Mr. Newman. Now I'd like to recognize again Vice Chair Brown. Could you please restate the motion?
The motion that I was making is that there would be a two-member committee that would work on the matter and come back with the plan of action for the December meeting.
Would you like to name who those two members may be? Is that necessary?
So that would be left up to you, the chair.
Okay, so it has been, there's a motion on the floor to create a two-member committee to discuss the subpoena power and for those two members to come back and to share some of their work for the December hearing. Is there a second?
I will second, Chair.
Okay, it has been properly moved and seconded that a two-member advisory committee is established to preliminarily discuss the task force subpoena power. Is there any discussion on this matter? Well, in terms of discussion, I will say, it's great that we have volunteers who are experienced and, have expressed interest in doing this work. So I definitely think the committee should be comprised of Member Holder and Member Tamaki. Is there any other further discussion on this matter? Hearing no further discussion, I will now turn it to Parliamentarian Johnson, who will turn to Ms. Belton so that a roll call vote may be established.
Yes, Ms. Belton, would you please call the roll for the vote?
Thank you, Chair Moore and Parliamentarian Johnson. We will go in order. Chair Moore, your vote, please.
Aye.
Chair Moore votes aye. Vice Chair Dr. Brown? I'm sorry, Vice Chair, I didn't hear you. Vice Chair Dr.
Aye.
Brown votes aye.
Aye.
Senator Stephen Bradford? Dr. Cheryl Grills?
Aye.
Dr. Cheryl Grills votes aye. Lisa Holder?
Aye.
Lisa Holder votes aye. Assemblymember Reginald Jones Sawyer?
Aye.
Assemblymember Reginald Jones Sawyer votes aye. Dr. Javon Scott Lewis?
Aye.
Dr. Javon Scott Lewis votes aye. Don Tamaki?
Aye.
Don Tamaki votes aye. Councilmember Monica Montgomery Stepp?
Aye.
Councilmember Monica Montgomery Stepp votes aye. Madam Chair, on the motion,
I didn't hear
there are 8
Bradford.
members.
This is Bradford. I did not hear my name called. This is Steve Bradford. I did not hear my name called.
Senator Bradford, your vote, please.
Aye.
Senator Bradford votes aye. Madam Chair, there are 9 members present and voting and 9 aye votes.
Thank you, Ms. Belton. The vote was 9 ayes and 0 nays. The ayes have it and the motion carries. Thank you. So we have established that there will be an advisory committee of sorts that will begin to start the work regarding our subpoena power and our strategy behind that. And we'll make sure to discuss this again tomorrow in agenda item 18 to make sure that we agendize this discussion for the December hearing. Thank you, Mr. Newman and Parliamentarian Johnson, for your assistance and work on agenda item number 9. Now we will go to agenda item
Madam
number
Chair,
10.
I'm sorry, Madam Chair, did you name the 2 members of the committee?
Member Lisa Holder and Member Don Tamaki will be a part of that advisory committee.
Thank you.
Thank you for that. Okay, now we will move to agenda item number 10, which is an information item, Department of Justice updates. Mr. Newman, you have the floor.
Thank you very much, Chair Moore, for acknowledging DOJ staff so that we may provide this update. We have a number of items to cover, so I'll go through it and then be available to answer questions. With today's DOJ update, I have, as I mentioned, numerous specific items to address in response to concerns raised in the last meeting or by members directly with our office or by members of the public in communications with our office. Before I do that, I would like to first share that our Chief Deputy Attorney General, Venus Johnson, had hoped to have been able to attend and speak as part of our DOJ update, but was unfortunately not able to do so today. I would like to start by saying that on behalf of the numerous members of the DOJ team working to support the task force in carrying out its important work in this landmark effort, we are eager to move forward together at the direction of the task force, and I welcome this opportunity to provide some information to the members and to the public and to seek direction from the task force as a whole as we move forward. There were some questions raised at the end of the last task force meeting in September and in subsequent questions and comments to the DOJ regarding concerns about the DOJ making unilateral decisions, including relating to witnesses and agenda items. I would like to assure both the members of the task force and the public that this is not the case, and we view our sole role here as to support the task force in executing on its landmark opportunity to shape the national conversation around reparations, and to do so in a way that fully complies with the procedural requirements in which we are operating. Specifically, I'd like to assure you that the DOJ is not and will not be making any final decisions or making any decisions whether something should or should not be agendized, unless adding or removing a particular agenda item would violate the Bagley-Keene Act. It is within the task force's power to revisit the overall public hearing plan that it voted to adopt at any time, as well as the agenda for each meeting, as we've just been discussing during the agenda setting discussion of the prior meeting by a vote of the full task force. And we will, of course, execute on this direction. Additionally, I'd also like to provide some more information regarding the selection of witnesses for each meeting of the task force. At this point, I can confirm that for this meeting and moving forward, all witnesses are coming through the task force members themselves, even where potential witnesses recommended by task force members are not available for meetings. DOJ staff is working with task force members to elicit additional recommendations to fill gaps in various subject matter areas. We have now circulated names and information for over 150 potential witnesses. We are actively seeking additional suggestions in advance of each meeting and as we work through the agenda setting for each meeting with the chair and the vice chair. I believe there was a suggestion in the last meeting relating to the delegation to a member of the task force. As we just talked about, the task force has the ability to delegate to one member the authority to do something on behalf of the task force. And I believe there was a suggestion in this regard in the last meeting to work with us to direct us and facilitate the vetting of potential witnesses. We would certainly welcome that if the task force were so inclined, given the significant work it takes to track down, communicate with, and confirm the availability of the numerous potential witnesses that, as you see, we have in each of these meetings. But on behalf of the DOJ, perhaps most importantly, I apologize for any miscommunication or misunderstanding on the part of anybody as to the setting of the agenda or the coordination of witnesses for these meetings, and especially am regretful that this communication distracted in any way from the very impactful testimony the task force heard or the critical task with which the legislature has entrusted this task force, which is the guiding principle of all of our work. In addition to these broader issues, there have been several other issues raised, which I will respond to now in order that the task force as a whole be able to address these items as a group and ask questions of me about these items and make a decision as to whether to act on the items. First, we have been asked about holding meetings of the task force on Saturdays. If the task force as a whole directs us, we'll conduct an analysis and provide a report at the next meeting regarding the feasibility of Saturday meetings. As you all know, these meetings are set in advance according to the dates on which the most task force members are available pursuant to a group calendaring poll in order to ensure a quorum. Based on your instructions, we'll be including Saturdays as an option for members to select in setting future meeting dates. Beyond the task force holding meetings on Saturdays, we are also hopeful that the community engagement plan that the task force has voted to implement will provide an extensive opportunity for the public to be engaged in all aspects of the eventual report and recommendations of the task force. We have also discussed the conclusions and reports that the task force will be generating. First and foremost, we look to the task force members to draft the conclusions that will guide the final reports of this task force. We in the DOJ are here to support the crafting of the final reports at the direction of the task force. As I mentioned in the earlier presentation on subpoenas, the task force will need to make decisions about how the report drafting should be handled. As with subpoenas, the task force has a number of options. First, I don't want to repeat myself, but I will, just so you have all the information again and how this would work in this context. The task force can vote to set up one or more report drafting subcommittees of 3 or 4 members each, which would be governed by the Bagley-Keene Act and would have to handle their report drafting and compiling process in public, but which would be able to make final determinations and would not require time to be utilized during the meetings of the full task force. Second, the task force can vote to assign members of the task force to advisory committees of 2 members, just like we just did with regard to setting the subpoenas with members Tamaki and Holder. The task force can set up advisory committees of 2 members to take on different components of the report. And if you choose that approach, those 2 advisory committee members would be able to work directly together on the drafting of the report, and then would need to bring the final drafts back to the task force for final review, comment, and approval by the task force as a whole which would require time during a regularly scheduled task force meeting. Finally, the task force could vote to designate individual members to handle the various components of the report and have the components of the report come back to the full task force for review and final votes to approve. If the task force would prefer, you can agendize this issue for the next meeting or future meeting, and we can send the board more information regarding all of these options. Again, when I'm finished, I'll be happy to answer any questions you have regarding any of these options. I have just a couple more specific issues. We have received numerous press inquiries regarding the important work of this landmark task force. The DOJ cannot speak for the task force, so again, you may want to consider either designating a member to serve as a press liaison for the task force, or this could be or may already be envisioned to be something that the communications consultant that Member Grills is coordinating through the community engagement plan would handle. Alternatively, if you do not wish to designate a member, then we can provide the inquiries to the task force in the meeting materials, and the task force can handle them as a group during future meetings. Finally, we have been asked for clarification regarding the availability of various types of accommodations for those seeking to engage with the work of the task force or to provide public comment. I encourage any member of the public seeking any kind of accommodation, clarification, or the opportunity to provide input to contact us at reparationstaskforce@doj.ca.gov. Again, reparations task force, all one word, at doj.ca.gov. All requests for accommodation will be evaluated as quickly as possible according to the applicable standards for accommodation, and we will be in communication with the requesters to ensure they are aware of the handling and status of their requests. The Blue Jeans platform, as well as the DOJ website that hosts the Reparations Task Force's information, both have a number of accessibility features built into them that should also allow for members of the public to have access to all information and to engage with the task force fully and equally, a principle to which the DOJ is fully committed. With that, I thank you very much, Chair Moore, Vice Chair Dr. Brown, and the members of the task force, providing an opportunity for the DOJ to clarify our role in supporting this task force, and I welcome any follow-up questions from any members of the task force about anything I have discussed or anything that I have not addressed the task force members wish to seek clarity on. Thank you.
Member Holder, you are recognized.
Thank you, Chair Moore, and thank you, Mr. Newman. That was very comprehensive. I do have a question. We've heard a number of public comments regarding the closure of the chat room, and some frustration since that seemed to facilitate engagement. We understand some of the current concerns raised by the DOJ, but it does seem that there is a balance of interests that should be taking place. I wanted to get your feedback on that.
Yes, I'm sorry, and I forgot to mention the chat function that was on my list. So I'll tell you, we have also heard from members and the public about the availability of the chat function in Blue Jeans. This function was inadvertently and accidentally activated in the initial meeting of the task force. As many noted, the comments in the chat were in some instances inappropriate and hurtful. The task force as a whole previously voted to have public comment handled at the beginning of each meeting day with expanded time for each commenter. The chat function is a different outlet for public comment, which for free speech purposes cannot be moderated once it is activated. Ultimately, the decision of whether to have the chat function active in meetings conducted on Blue Jeans is the task force's to make, not ours. And so in order to resolve this question, we would defer to the task force members to provide direction on this function's availability during meetings, including whether to agendize the issue for discussion and action in a future meeting. In other words, whether to turn it on.
Okay, so in other words, this is something that we can bring up tomorrow at the last hour. We can, put this on the agenda for December, a discussion on opening the live chat feature and taking any action on that in the December hearing. Yes, so I had a clarifying question, and this relates to the press inquiries. So yes, as you stated, we have received numerous press inquiries. Some of them, or many of them, we have missed because the meeting materials, come at a certain time, and so I've just for transparency, I've asked DOJ staff to elevate press inquiries so that we are not missing anything. I think that, any press inquiries at this point should be sent to Vice Chair Brown and myself. But in the event, not to say that me and Vice Chair Brown will take all the interviews, but as Vice Chair and Chair, we could field them. But if we need to put this on the agenda for December, we can discuss that tomorrow as well. Just putting that out there that, this is very important work and we can't afford to miss a press inquiry because the emails aren't being monitored or elevated in a timely manner. Are there any other questions or comments from the task force members related to the update from the DOJ?
Madam Chair,
Yes, Vice Chair Brown.
I want to acknowledge your leadership and Mr. Newman's leadership in ironing out the concerns. And we have done what we do when we have a wrinkle in our shirt or our blouse. We don't throw the blouse or the shirt away if there are wrinkles. We meet the task of ironing it out. And I think everything has been ironed out as it regards the work of this task force.
Absolutely. Yes, thank you for that. I would agree. Great progress has been made, and we are optimistic about the future of this work. So thank you for that offering, Vice Chair Brown. Are there any other questions or comments that could be directed to Michael Newman at this time? Member Tamaki, you're recognized.
Thank you, Chair Moore. Mr. Newman, I really appreciate your input. And, I can only speak for myself, but I think this task force has actually accomplished a lot. And the witnesses have been riveting and substantive and really good. The DOJ has produced 6 of 12 outlines, which I find to be comprehensive and very good. Maybe other task force members might have a different opinion, but my impression of the outlines and the materials so far have been really excellent. And most of the footnotes are very well, most of the outlines are well footnoted and well referenced. And so the amount of research that has gone into them is an enormous amount of work. I would expect that the report itself might end up to be 1,000 pages or longer, maybe 2,000. And so just to add to the discussion, we can't be successful without a good working relationship with the Department of Justice. So I really appreciate DOJ's efforts and your effort. I'm wondering if we could facilitate a little bit more communication from the task force. Right now, the burden has fallen on Chair Moore and Vice Chair Brown, which, I want to extend my appreciation for that. But Bagley-Keene, by the same token, prevents Chair Moore, for instance, from calling me or calling any of the task force members, because it then triggers basically an illegal meeting. And so to deal with that and maintain the purpose of Bagley-Keene, but to ameliorate the blockage of the information flow, I'm wondering if someone from the DOJ could be assigned as a liaison to the task force to actually communicate to each of the task force members in between the meetings. So we have additional flows of information. So things like the witnesses and the agenda and subpoenas and other discussion, other task force members could be more fully informed. And so we come to these meetings, better prepared. And I think that would help the information flow. It means a lot more work for the DOJ, I know. But I think because of the structural, legal requirements of Bagley-Keene, I can't think of another way to increase the information flow to the other task force members, because on some of these issues, we've been kind of necessarily in the dark because of the barriers. And if you might respond to that, I would really appreciate it.
Chair Moore, may I respond? Okay.
Yes, Mr. Newman, you are recognized.
Thank you. Thank you, Member Tamaki. And I think you've hit on the key issue. This task force has met exclusively virtually. Many people may never have met, and certainly you have not had a chance to meet in person the numerous staff that have put in, innumerable hours working on the task force, both the report and facilitating the meetings, the witnesses, many witnesses. And so I agree with you that that's something that we see on our end too, and we do commit to in making sure that there is increased communication, consistent communication between the meetings with all the task force members. I probably am not in a position right now to designate a particular person as I sit here, but I hear you. Obviously, as you've seen, I have been engaging in communication, and that'll probably continue in the short term. But I do anticipate that we'll figure out a long-term solution that will make sure that each of the members are briefed, are aware what's happening in the meeting, have an opportunity to weigh in, ask us questions. Maybe the DOJ updates don't need to be as long and detailed, and you'll have the information before we present it, or in anticipation, background information, so that you're ready for the meetings. So I definitely think that is something that is already hopefully happening. Hopefully everybody feels like that's already happening and will continue to occur. One-on-one conversations with members of the task force.
I have one more comment about the conclusions. So may I continue on that point?
Yes, Member Tamaki, yes.
Elevated me to doctor. I like that. With respect to the conclusions, Mr. Newman, you sort of delineated three pathways, and one was the task force can set up a subcommittee, which would be subject to Bagley-Keene. Of three or more, 2 members could be assigned to take on the report writing and this sort of thing, or the task force could delegate to a specific member. I guess there's a fourth option, and I wanted to know if the other task force members too have a thought on this. When we talked about sort of this bifurcated process of findings and conclusions, I don't think we had in our possession yet the outlines. And then since then, the next meeting, certainly by September, we had 4 of the outlines, which were very I think, comprehensive. We got another 2 outlines covering healthcare and racial violence. And so they're filled with findings and conclusions. I mean, they're there. So, I mean, one option would be for the task force as a whole to read them and comment as to anything that they think is not comprehensive enough, not detailed enough, or inaccurate, or missing, or wrong. You know, the only reason I raise this is each of the task force members are extremely busy. They're extremely busy, and so I'm just wondering if the task force members have the bandwidth to actually do writing and analyzing, and should we instead rely on the expertise of the historians, the PhDs, the experts, and the attorneys that are, you know, dedicated to this process, that are producing drafts, which are already contain both findings and conclusions for us to then weigh in on. You know, of course, I defer to the judgment of the task force, but just an observation, it seems to me there's a 4th option for us.
Chair Moore, may I speak?
Yes, Member Grills.
Yeah, I just wanted to echo what Member Tamaki just said regarding these conclusions, that I think that it still would be a product that has our seal of approval, our input, our edits, our additions, but that we let the DOJ staff do the initial draft that we can then respond to and contribute to, and including deleting things that we think may not actually fit. I just feel like, you know, having worked on other commissions, that's the typical way things are done, and it doesn't represent that the supporting body, in this instance DOJ, is in fact driving the train. It's more about how we are efficiently developing and delivering the product that we are charged with developing. Did we lose Chair Moore?
Yes, I'm on my phone right now.
It looks like we lost a few people.
They're frozen. No.
Okay, I'm back now. I should be good. Sorry, Member Grills. I did not hear your question or comment.
Oh my. Okay. So I was simply agreeing with the recommendation that DOJ actually draft these documents, these components of what will be our findings and conclusions. And that does not stop us from editing, adding to, deleting to that document, but it just feels like it would be a more efficient way to do the work at hand. And it is not uncommon. In fact, I tend to see this as more the way it's typically done on commissions and task forces.
Would that mean, for instance, so the September hearing, the DOJ staff sent us some draft findings. For the October hearing, they also sent us some additional draft findings. And our task was to come up with conclusions based on those findings. So based on I guess, Member Tamaki and Grill's offering, would that mean we would no longer be drafting the conclusions?
It means that we would let DOJ finish the process and document the conclusions, and then we could then weigh in on what they have drafted, making recommendations for changes, either inclusion, exclusion, refinement, nuancing, etc.
Yeah, just to add to that, Chair Moore, just to add to that, I found the evidentiary findings pretty scant as compared to the outlines themselves that go on for many pages. And so I was having difficulty wondering, well, why was this particular finding plucked out of a 50-page outline on a topic? And I looked at the outlines, and they seem to be very comprehensive with respect to, and well footnoted, well researched evidentiary findings. And then on top of that, embedded in there are conclusions on literally every page about, the downstream consequences of segregation or Jim Crow, or the rise of the Ku Klux Klan, or generational trauma, or whatever the subject is. And so, I mean, there are the findings plus the conclusions. So wouldn't it be really up to us to basically look at those, be comfortable with it, or revise them in a way that task force members, would deem fit? And I say that mainly because given that everybody's really extremely busy schedules, that, maybe there's a more efficient way of doing this, but yet still have it be the product of the task force, if that makes sense.
Madam Chair.
Yes, Parliamentarian Johnson, you are recognized.
Thank you. I'm suggesting that perhaps one of the members should make a motion once they've decided what they want, just to have them make a motion that can be acted on.
Would any task force member like to make a motion regarding this item, this discussion?
Okay, I'll try to frame it. I move that the task force charge the DOJ staff